Hear the Court of Appeals of the State of Michigan is now in session. The Honorable Michael J. Kelly, the Honorable Adrian N. Young, presiding, the Honorable Thomas C. Cameron. All persons having business herein drawn near to the Ms. Young for state of the United States, State of Michigan, and its Honorable. Well, good morning.
Morning.
On behalf of Judge Kelly and Judge Young, I'd like to welcome everyone to our last day of hearing cases here in Detroit. I would just note that we do have a number of cases that are up today with minor witnesses. I'd ask you not to identify them by name, initials, child, that sort of thing, rather than identify the person by name just to protect their anonymity. But with that, why don't we jump right into it by calling the first case on the docket today, which is People of the State of Michigan versus Murray, 371913, consolidated with 371914.
I saw a number.
Is that right? Do we have anyone endorsed? This first way. Oh, she did. All right. All right. In light of that, the matter is submitted. Turning now to item number 15, People of the State of Michigan versus Joshua Smith, item number 370661.
Morning, Your Honors.
Morning. Go right ahead.
Morning, Your Honors. APA Adam Kuntz on behalf of the appellee, P87076.
All right. I have. Nobody checked in. I do. The person was endorsed though, correct?
Correct.
All right. Well, go right ahead.
So, Your Honor, the people are willing to rest on the briefs. I am more than happy to answer any questions that any of you may have.
Questions?
I don't.
I don't have any.
All right. The matter is submitted. Thank you very much. Turning now to the next case, item number 16, Goff versus Vitae. That's item number 371827.
May it please this honorable court. My name is Victor Bowman. I am here representing the plaintiff in the stead of the attorney of record, Michael Fortner. My P number is 33764. I understand that there is no oral argument today, and I will attempt to respond to any questions that the court may have.
All right. Any questions?
No, I don't. Thank you.
I don't have any.
Okay. Thank you very much.
Thank you.
All right. Why don't you take a seat and we'll see what the appellee has to say. Go ahead.
Have a good day.
Yep. You too.
Good morning.
Morning.
My name is Theophilus Clemens. I represent the defendants appellees in this matter, P47991. We're prepared to rely on our brief. If the court has questions, I'm prepared to answer those.
I have none. I think the briefs covered it pretty well.
Yeah, I thought so as well. Thank you.
Thank you, Your Honor. Thank you.
All
Have
right.
a
You're
good day.
welcome. Yep. You too. Matter is submitted. Turning now to item number 17, New Products Corporation versus Mutzel Long.
Good morning, Your Honors. Mark Demarest. I represent New Products Corporation. I'm available to answer any questions, but I understand that we don't have the right to oral argument due to a question about the timing of our brief, but I'm available to answer any questions the court may have.
All right. I don't see any questions right now, but thank you very much for
Thank you,
being
Your
here.
Good morning, and may it please the court. I'm Trent Collier for Pletzel Long. I'm the only endorsed party, and this is a world record fastest case call, so I don't want to mess that up. I just really want to just briefly comment about our basic theory of the case, and otherwise leave it to the court if you have any questions. From our perspective, the key issue is causation, and specifically causation under Boyle versus Odette and Mitchell versus Doherty. And these cases hold that when a deadline falls after an attorney stops representing a client, that attorney is not responsible for missing that deadline. That responsibility falls to the former client or to the former client's new counsel. And so in our case, the question is, did the key events occur before or after Butzel Long stopped representing new products? The new products complaint says they stopped working with Butzel Long by December 2008, and they hired new counsel by I believe it's August 2009. So again, from our perspective, the task is to go to the 2019 opinion from this court, the New Products versus Harbor Shores case, and look at what was driving the court's conclusion that latches applied, and that the Marketable Record Title Act apply. We submit that the key events are the 18th hole was seeded in 2009. The 18th hole was open for play in August 2010. In September 2010, they lost the last alternative placement for this 18th hole. And in 2011, the course opened. And so that was all of that was after Butzel Long was involved in the case. And this court was very specific about relying on these factors. In the 2019 opinion, the court said, rather, plaintiff waited until 2011 after the golf course had been completed and open to the public to file its complaint and seek an injunction. Later, the court said, plaintiff waited for months while the grass grew on the 18th hole and only took action after the public started golfing on it. So what the court is pointing to is that latches applies because of things that happened after Butzel Long represented this plaintiff.
But I thought this court and the Berrien Circuit Court cited events in September 2008 that NPC should have acted affirmatively on or around. And by NPC, I mean through counsel. And that was when Butzel was representing them. Isn't that right?
Yes, it's true. That was when Butzel was representing them. It's also true, as Your Honor pointed out, that that's what the trial court said. Our position is the trial court's rationale was superseded by this court's rationale. So, what the trial court said may be interesting or persuasive, but it's not controlling. It's got to be this court's analysis that controls. And that's in the 2019 opinion that we refer to. So that's how we view latches. I think the Marketable Record Title Act is
You
even.
read New Products too from this court as expressly saying which law firm is responsible for the failure.
I'm sorry, Your Honor, I didn't catch the whole version.
You read the opinion from this court, which I'll call New Products too, as expressly saying which law firm is responsible for the failure.
No,
Okay.
I would not say it's express in the opinion. And I think there's actually a footnote where the court talks about, if you have an issue with this, you may be able to resolve it with a malpractice claim.
Mm-hmm.
So for us, it's, the opinion is controlling because of stare decisis. The court resolved these factual issues. And so what our argument is that this court should follow the analysis of its previous opinion, not the analysis of the trial court that led to that opinion. So for the Marketable Record Title Act, it's a 40-year period. It started in 1971. It ended in 2011. That one's even easier because, there's no dispute that that Butzel Long's representation did not go past August 2009, which was before the Marketable Record Title Act ran its course. So that's another issue where Boyle versus Odette and Estate of Mitchell would require the conclusion that there's no causation. That's our argument in essence. I can get into more of it. I think everything else is briefed, but I'm happy to answer questions.
Oh, I think I understand the issues.
All set. Thank you.
Thank you.
Thank you.
Good evening, Your Honors.
I don't think so. Not
I
for
don't
me.
have anything.
All right.
Thank you.
All right. Thank you both very much for being here. The matter is submitted. Turning now to item number 18. Mr. C's P&M LLC versus Charter Township of Chesterfield, 374292.
Good morning, Your Honor. Robert Kirk on behalf of the appellants in this matter. I'm sure you're aware of the facts of this case. I want to point out a few issues with regard to our standing issue. I think we meet the standards set forth in Sagatuck 1, 2, and 3. The first one meaning you contested it and appellees admit to that. The problem we have in this case is with regard to the proofs that get put on the record to meet the second two factors in Sagatuck. Those being a property interest or any damages, those were submitted as part of a letter from me, May 21, along with a letter from our client. He's been in the business for years. It's going to damage him. The problem we have with Sagatuck, and I think it's a practical problem, is that at that level, it's hard to establish your record. Because if you go on the record at a planning commission meeting, you start talking about economic factors, they're going to shut you down, say it's just planning. So I do submit those letters regularly. But the other issue we have is that Mr. Catalfa was at all the meetings, testified or made his presentation, and the minutes that meet the ordinance, that meet the statute, only say 9 people spoke. He's one of them, 8 were against it. So it's hard to meet these factors, but the affidavit we submitted to the circuit court kind of codified all of our arguments. But I think all of our arguments were made. I think we meet the Sagatuck standards. I think the cases that we cited along with Sagatuck, being Beverly Hills, the Tuscola case, kind of follow that. The Beverly Hills case has Sagatuck has kind of a low standard. But I think clearly with our client, with their experience, and the one other issue with regard to our use is that we're governed under the same ordinance that Mr. Car Wash came in under, that being a special land use, and you have to show that there's a public need for it. So we've abided by it. I think those factors go to it, that we meet the Sagatuck factors, and we request that the trial court or that appellate circuit court be reversed.
Okay. Thank you.
Morning, good morning, Your Honor. Robert Seawood appearing on behalf of the appellees. As Mr. Kirk indicated, it's a very single, very narrow issue before the court. The Michigan Supreme Court in Sagatuck Dunes set the bar. That was the first case that the Michigan Supreme Court ever decided the issue of what aggrieved party status means under the Michigan Zoning Enabling Act. And the court indicated that was the first opportunity they had, and they spent a considerable amount of time in that case laying out the 3 factors. I have conceded in the lower court and in this court that they participated in the lower court proceeding, lower tribunal proceeding, so that's a non-issue. What's before the court is how high the bar is to determine aggrieved party status. The appellants are essentially saying that if you're a property owner or a lessee in close proximity to a proposed land use, the mere fact that it may be anti-competitive is enough to show aggrieved party status. If that is in fact true, there is no standing bar. Anyone who is in close proximity to a proposed land use who simply alleges that business is going to cause me harm because it is anti-competitive, whether it's a car wash, a fast food restaurant, an auto dealership, all they have to allege under the plaintiff's theory of this appeal is they're going to cause me damage because it's anti-competitive. It's true, Mr. Kirk in the lower tribunal submitted a letter to the Zoning Board of Appeals, and he went through the standards for special land use, and they alleged the common arguments that every disgruntled property owner opposing a development makes. There's too much traffic, it's not harmonious with the surrounding land uses, there's too much noise, and on and on and on. Sagatuck Dunes said that's not good enough. Everybody, you're not alleging anything different than anybody in the community would allege. You are required to prove, not allege, but prove that you are likely to incur or in fact have incurred actual special damages separate and apart from the
How do you
community.
prove it?
Yeah.
I mean, do you have a trial
No,
What's
you,
what's
no,
the burden of proof?
no, you don't have to have a trial, but on the other hand, you have an opportunity as the adjoining property owner to submit prior to the zoning board of appeals meeting, whatever written submissions you choose to submit.
Let me just add on to Judge Kelly's point. The second element is that the appellant must claim some legally protected interest. It doesn't say must prove some legally protected. interest.
That's not what Saugatuck Dune says. Saugatuck Dune says that that the party, that you must show or prove that the special damages are likely to occur, or you have to show actual damage. And we both cited that case exhaustively in our briefs. It requires proof, and a simple allegation of lost revenue or anti-competitive nature of the proposed land use is not sufficient. If
A
that's
portion
all-
of the opinion that Judge Cameron was citing is Saugatuck Dunes at page 595, where it says, first, the appellant must have participated in the challenge proceedings, ellipses, which nobody contests. Second, the appellant must claim some legally protected interest or protected personal, pecuniary, or property right that is likely to be affected by the challenge decision. That seems to be what's happening here, is that they're claiming a pecuniary interest. And then third, I think, is what you're talking about, which is separate from what Judge Cameron referenced, which is the appellant must provide some evidence of special damages arising from the challenge decision in the form of an actual or likely injury to or burden on their asserted interest or right.
That is exactly the argument I'm making. That says actual or likely, and you have to have some evidence.
Some evidence.
Some evidence. And so they have claimed throughout, when you take away all the too much traffic, incompatible with surrounding land, you throw all that out, which Saugatuck said you have to throw out. And you look at the question of whether or not you have a loss of revenue. The only thing that they asserted was in the reply brief in the circuit court, they attached an affidavit of the owner. That is completely outside the record. That's not permissible. When you take an appeal from a zoning board of appeals to circuit court, you are limited to the record. We provided a stipulated record, meaning both lawyers signed it, and we submitted it to the court. Nowhere in the stipulated record to the circuit court was the affidavit of appellant's owner. They brief it, I brief it, then they file a reply brief, and they attach to it for the first time outside of the record the affidavit. And he says, oh, by the way, let me tell you about all my special damages.
What's your response to the plaintiff's assertion that it did that because it didn't become an issue until they appealed the decision to circuit court?
My answer to that would be this court has said dozens of times you cannot supplement the record. The record is what is before the administrative body before it goes to circuit, i.e., what did the zoning board of appeals have in front of it when it made its decision? And that affidavit was 6 months removed from the zoning board of appeals hearing. They submitted in the circuit court for the first time. That wasn't before the ZBA.
But a party seeking relief from a ZBA decision has to establish that they're an aggrieved party.
Yes, they could have done that at the ZBA proceeding. They could have come in with Mr. Catalfio's affidavit. They could have come in with financial data. They came in with an even that affidavit alone. What he says is there's 7 car washes within 2 miles of this, of my facility, and 5 of them are operational, and there's 2 that have been approved. Yet this particular car wash, Mr. Car Wash, is going to put me out of business. That's his allegation with absolutely no evidence whatsoever. And Judge Fonts got it right when she said that is pure speculation. There is nothing in the record to substantiate that. And even if you accepted the affidavit of appellant's owner, it's still insufficient, and it's clearly outside the record. There's not.
I mean, we're far away from your original comment that they have to prove. I mean, this says provide some evidence
Okay.
of something actual or likely.
Okay. Some evidence.
Yeah.
They presented no,
Actual or likely.
and they presented none. Their argument is, I own a car wash, and this is 598 feet away. Therefore, I'm going to lose revenue, and they're going to put me out of business.
Oh, losing revenues. I mean, Seems.
But that is an
likely that that would
allegation.
happen if you have to, that-
Yeah, but there has to be a factual basis for the allegation. I'm going to lose, there's a car wash across the street. I'm going to lose business. How do you know? You don't know that.
Do you have to just wait and document the fact that I'm now out of business? Like, it's a little bit circular, right?
Well, there's
Because the
5
whole
car
point
washes
is-
within 2 miles of it and they're all operating and he put in his own affidavit that they
Yeah,
are.
but there's a difference between one 2 miles away and one across the street. I'm driving down the street. I decide I want my car washed. Here's one, here's another.
Products are
The
different.
people that decide to go to the one across the street from this one are likely to cause him to lose business.
But you're inferring something. Judge,
Common sense. I don't think it takes a genius to
But-
come to
but-
that conclusion.
But the Supreme Court didn't set the bar so low, is all you have to do is make the allegation. They didn't say that. They said you have to have some evidence. And there is nothing in this record that supports the appellant's position that this new car wash is going to put him out of business at all. They don't want a competitor. Yeah, I mean, you can drive anywhere around the Tri-County area and see auto dealership after auto dealership after auto dealership, all within 2 miles of each other. Nobody's going out of business. They're selling a slightly different product. Car washes are different. You can put the ones you go in and you put in a couple of quarters, you get your car washed. You can go in and pay $40 and it looks like a brand new car when you're done. They're different. It's a different service. No different than a Taco Bell and a Burger King and a, you name it, McDonald's. They're all right next to each other. They're within 100 yards of each other and they're
The
not going out of.
existence of competing industries in the world doesn't mean that it's entirely possible that the McDonald's lost revenue. You know, in the context of the ZBA, you just need to show some evidence of a likely injury. So you could present the fact that having the exact same business 598 feet away is likely to provide to have a pecuniary injury on your business that operates in the exact same model.
I would respectfully says who? They could compete with it within 500 feet of each other for decades, and they may both get business. There was a traffic study done in this case. This is on 23 Mile Road, which is a 5-lane highway. One of the traffic studies showed that there's almost 60,000 cars a day on 23 Mile Road. 60,000. These are car washes where you may have 8 or 10 cars lined up to get their car wash and they leave. There's 60,000 people that can go to different car washes. And the fact that they're 600 feet apart, again, if the court takes the position that's all you need to do, what you have now done is said that any business that is located in close proximity to a similar business,
An identical business.
well, they wash cars, but that doesn't mean the service is the same. McDonald's and Taco Bell, and they're all fast food. They sell different products. Car washes are different. We've all been to them. Some are great, some are not so great. The fact that they're there, the mere allegation that they're next door to me and they do what I do, I now have standing. That's going to be a first. And there are no other cases that say that. There are no other cases. Remember, Saugatuck set this is the first case in Michigan where they said what that test is. Judge Viviano, in his dissent, was very unhappy because he thought that the Supreme Court set aside 60 years of law and changed the test entirely. And the Supreme Court went out of its way to say, these generalized concerns don't matter. You've got to come in and show special damages. It's no different than standing in a lot of other contexts. You have to show some evidence. What the bar for the some evidence is not yet to be determined, but you still have to show something. And if all you have to do is allege they're across the street from me, and so the court can infer, there's not a circuit court you could walk into if you had to do a burden of proof and say, Judge, we're going to prove our damages by saying they're across the street. The court's going to infer damages. You know how many circuit court judges would buy that? Zero. You have to come in with some evidence. And I'm not suggesting the ZBA is a court of law, but they had to come in with more than they had. And if Saugatuck Dune stands for anything, it stands for the fact that the appellant has an obligation to present some evidence of actual, which they didn't, or likely, which they didn't, injuries.
So there's 2 questions. First is the issue of agreed party status. I won't call it standing, agreed party status. And then another aspect of it is the adequacy of the proofs.
Yeah, if the court were to remand this back, Judge Florence did not look at the record. At that point, we'll go back. She'll say, fine, the Court of Appeals has ruled that they're an aggrieved party. Now she's going to determine whether or not the ZBA's decision was supported by law, whether it was based on competent material and substantial evidence on the record, whether there was an abuse of discretion, and whether procedure was followed. Those are the four standards. She'll do that. And if she finds that the ZBA got it right, it's game over for the appellant.
Right.
She took the first issue that I argued that they're not aggrieved.
All right. Any other questions?
No.
Yes, correct. Yep.
You're correct on the case going back. I'm actually handling the Beverly Hills case. That got dismissed on standing now. We're going all the way back. We're in circuit court next week arguing those factors. With regard to the financial loss, Mr. Seaver talked about, Tuscola involved windmills next to an airport. They said that's going to affect your operations and money, so you have standing. Beverly Hills said that's competing, I guess it's a next door childcare. If one parent drops off a child next door, that's going to affect you. So I think those are the standards. And as far as the evidence with regard to my submission, he said no evidence was presented. Look at Exhibit 6, which is my letter. It references a car wash publication that says car washes are adequate within every 3 miles. That we have 3 within 7 or 7 within 2. I also attached all of Mr. Catalfio's statements that he said at all the meetings with regard to what it's going to do to damage his business. Those are exhibits to mine, which was submitted to the ZBA. Unfortunately, the ZBA and the Planning Commission minutes are woefully inadequate. They don't say who talked, what they said. So we're stuck with that. I've done 1,000 of these meetings, so is he. It's really frustrating.
If Burger King wanted to open up a franchise right next to a McDonald's, would they be an aggrieved party?
They could be. In this case, I think it's important that they're both special land uses and you have to show a public need for it. That's one of the factors, I guess, if it goes back, Judge Fonce has to affect, but car washes are carved out here in this special land use that they have so a special need for it. So that's one of the arguments we're going to have, that I think we're the same exact.
But in terms of an aggrieved party, would they be an aggrieved party?
I believe they would be an aggrieved party, especially taking into account the underlying ordinance.
But it doesn't mean they win. It just means it
Right.
proceeds to the next step.
Right.
To prove it. That's where.
Sagatuck's
I
going
don't
to
see
protect
this as-
against the general public. I have got a half a dozen of these cases right now.
Right.
We have one in Livonia where residents 2,000 feet away, so they're going to be affected. I think Sagatuck tries to protect against that, but this one 500 feet away, same use, that's specially addressed in an ordinance.
Got it. Okay. Any other questions?
Nothing.
No, I'm good.
Thank you.
Thank you.
It's a slow day when a ZBA case is interesting. Thank you very much. That matter is submitted. Turning now to item number 19, Ola Young versus Kashat. That's item number 373554. Yes,
Your Honor, I believe that was scheduled for 11.
it is. Let me.
I'm the only one endorsed for oral argument, and I have no problem proceeding. It's just,
We'll be happy to wait if you'd like to wait to collect your thoughts, or we can go right now.
no, the collection of my thoughts would be fill the navel of a flea. So, no, thank you, Judge.
So let me just slow down a little bit. This is item number 19. I just want to confirm. Yeah, you're the appellant and you're the only one that's endorsed. Is that correct?
Yes, Your Honor.
Okay, then go right ahead.
So talk to us about, we got your email.
Yeah,
Talk to us about how that affects
It
the
actually,
case. This is the individual who passed away. Yeah.
well, first of all, may it please the court, Stephen Cohen appearing on behalf of the appellant. I learned something after 48 years when Ms. Young passed away. Apparently, the law calls it a suggestion of death.
Yeah, I always wondered what that meant, but
I mean, I'm not suggesting to the court, I'm telling you she died. I was at her funeral. So it's just an unusual use of the term.
It is. That's a curious phrase.
I've had some judges suggest that I should be dead, but that's a different issue entirely. It does not affect the case.
Okay.
Because there's now an estate being applied for the estate of Ola Young. The practical effects, taking my logic, which is dubious to begin with, but assuming that I win this case, then the house would go to the estate of Ola Young. And then, because Miss Young died without a will, in theory, Miss Kashat would be entitled to 1/3. She's one of 3 children. She would have a 1/3 interest in the house. So the best scenario is she can't be written out. Right now, she claims it's all hers, but it doesn't impact. The house is the house, and it's the only asset in the estate. So it doesn't impact, but anyhow, so now let me get to the meat and potatoes of why I'm here.
But your position is it doesn't moot anything
No,
in terms of the appeal.
no, if they're
But you'd have
false.
to amend the plead the heading or something at some point, right?
Yeah, no, I'd have to substitute parties.
Yeah.
Assuming you agree with me, it should go back to circuit. In the interim, and I'm going to tell you the history, and it was in my opponent's brief at length about how I had filed to reopen the estate of Kislomed, which is true, and that's been reopened, and a complaint similar to this has been filed. But I have to tell you, with great respect to opposing counsel, from the day I became involved as substitute counsel for Mr. Borman, this has been a delay game. Ms. Young's deposition was not taken because in the initial phase before Judge Faunce, even though she had just been diagnosed with cancer, he refused to attend a deposition because of his C10, C4 various motions. When the judge dismissed this and I filed the claim of appeal, worrying that she might pass so as to preserve her testimony, I opened up the estate. I made a motion. He challenged that. It took us months to get a personal representative and get it reopened. Then he challenged the personal representative. Ultimately, Lita Grubb became the personal representative of her mother's estate in the stead of Miss Young because opponent complained that she was ill. So her sister took over, and then he filed another motion to dismiss that case. And regrettably, before she passed, she was unable to sit for a deposition. She died before I could get her testimony. Now, the good news is I have affidavits, and I'll rely on handwriting experts, etc. So it's a rather sordid history. However,
Since you brought it up, but one of the things I was struggling with in this case is trying to determine, this is how you opened a moment ago, is whether the case was properly filed in circuit court or probate court. It strikes me that these claims could have been brought in probate court.
they could not, because they couldn't have been filed straight away. I would have had to challenge and reopen the estate of Elena Kislomed, which ultimately I did. That took months. The claims against Mr. Peters and Ms. Kashat vis-a-vis the destruction of the home and damage to the home, under any circumstance, Ola Young had a right to complain, assuming Kashat was right. She has a right to complain. Look at you, you destroyed the house that in theory I owned half of and own half of until I die. We wouldn't have been able to bring that. When Mr. Borman filed it, he apparently did the research and found that there is concurrent jurisdiction, which is our argument. The problem I think that Judge Faunce had, and I wanted to point this out, all the cases, and we cited, and it's unusual for us to do so because I can at least list 5 or 6 different circuit court judges who would have destroyed me for having suggested unpublished opinions of your bench. But I did because those are the ones that happened to come up that actually had to do with this issue. If you look at the original pleading, which is before the court in the record sent to you, the request made by Mr. Borman on behalf of Ms. Young was, plaintiffs respectfully request that this honorable court enter its judgment to decree, declare, and adjudge that plaintiff owns the subject property in fee simple. Now, the case law we've cited you indicates that generally speaking, if that's what you're asking for, it's within the court's jurisdiction. When the judge ruled And her ruling is wrong on two bases. Now, by the way, very nice judge, one of my favorites. But she ruled on a C10 when it was actually a C4. Because the only issue of jurisdiction was a C4. But she ruled C10, which left open issues of fact. When we responded, and in her opinion is probably mistaken in how her reasoning was. At page 3 of her opinion, she writes, furthermore, plaintiff contends that at the time she filed the instant complaint, she was unaware that a probate case listing her as personal representative had been opened to her mother's estates. And then she says, plaintiff states, if as alleged by the plaintiff, she had been unaware of a probate filing and that the adjudications in the Macomb County Probate Court were engendered by fraud, then the property remains titled in the name. That was actually the defendant's argument, not the plaintiff's. Well, wasn't my argument, but and this is where the practicalities of the law and the hyper-technicality of the opinion run afoul of the law. There's nobody's argument that Alina Costlom had wanted the house to go to her daughter, Young. Clearly, that's the case. When she died, when Miss Costlom died, by operation of law, and we've cited cases to you, it then technically Ola Young's, but for a transfer of a deed. Nobody could challenge it except somebody who defrauds her. So the question is, if I have to go back to probate court to try this case, probate court won't let me try the claims for the destruction of the property as against Peters and Kashat. They'll only deal with the issue of who owned the title. The problem with that is the only reason to go back to probate court is to have one court versus the other reach the ultimate conclusion as to who did she properly deed it to her daughter or not.
Let's say that the claim about the destruction of property doesn't survive. All right. With regard to your remaining claims, I know your position is that there's concurrent jurisdiction, but would those cases properly be before the probate court or the circuit court?
I believe it should be the circuit court because of its plenary jurisdiction, because I am expecting Mr. Wujik, who is ever diligent in this regard, to then argue. Right now, the probate court made a ruling on his motion to dismiss that case.
Can I interrupt you just for a minute?
Of course.
Because it seems to me that your claims for quiet title for quiet title depends upon a determination that's going to be had in probate court with regard to the validity of not the will, but the documents in question. So if I'm the probate court, if I'm Judge Fonz, how could I decide the quiet title action without knowing the validity of the underlying documents, which is going to be determined by the probate court?
Well, it doesn't have to be determined by the probate court. Probate court was opened by Ms. Kashat. She put forward 2 deeds and it gets closed. My client doesn't know anything about it. Therefore, the status quo when Mr. Borman filed his case for Ola Young was, it's not her property, it's jointly with her daughter. She challenged that on the basis of fraud. She asked the circuit court to quiet title in her name, saying that the documents that established that were by fraud. That's a circuit court matter. A circuit court has that plenary jurisdiction, and the judge could and should have exercised that jurisdiction. The argument raised by opposing counsel was, in my opinion, kind of a throwaway. You don't have jurisdiction, you got to go back and open the estate. Well, why? I have to go back, reopen an estate, appoint somebody else to challenge the fraud that's committed by the person who's now residing in the house and destroying the house? No, that's a circuit court matter. The judge, and I've forgotten her name, and I apologize, Shimke. Judge Shimke is the probate court judge in Macomb who has the probate matter. She ruled recently that, yes, I have a case go forward, but at the same time, you can't bring these other cases against them for the destruction of the property or conversion or anything else.
So what's open in probate court?
There is an estate open on the estate of Kisloman, And there is a lawsuit brought by Lita Grubb as the personal representative of the estate of Kislomid to set aside those deeds and to deed the property back to Ola Young,
Which is what you want.
which is what I want, but I can't get all my relief. The only place I could ever have gotten all my relief is in the circuit court.
So what relief can't you get in probate court?
Well, Mr. Peters can't be brought to task for the destruction of the property, neither can she.
I know, but my point is assume for today that those claims fall.
Yes.
What else can't you, what else can't be pursued in probate court?
Well, aside from the fact, I guess if I get it, I'm going to get a jury one way or the other. The answer is there is no difference in terms of that ultimate issue of fact. I can try it in either.
So my point is if you prevail on all but one of your claims, specifically the claim dealing with the destruction of property at the house, dealing with the daughter and the boyfriend. If you prevail on everything except for that claim, and we remand this case back to Judge Fonts. If I'm Judge Fonts, I'm like, okay, what now? I've got this other case that's pending in probate. I've got this all needs to go over to probate. That's what if I was Judge Fonts, that's what I'd be thinking.
Ms. Cameron, yes, that is what I would think if I ever had the temerity to wear a robe. However, the circumstance here is different. Mr. Wujcik has filed a counterclaim against my client, claiming defamation for the things, and he raised this in his brief ad nauseum. They've horribly harmed me. That's a circuit court matter, but now that's in the probate court. Now, I don't know if the probate court, we haven't gotten to the point where we're far enough along to know if they've got jurisdiction. Now, there are practical reasons. If I'm Judge Fonts, and I told Judge Fonts this in my oral argument before her, and I've said it in pleadings before, this case cries out for one court to handle all of it.
I agree.
The only court that can do that is Judge Fonts. She's got concurrent jurisdiction of what is now in probate.
Right.
The probate judge, Judge Shimke, threw up her hand and said, I can't get this. Judge Fonts says, I can't get any of it because it's got to go to Kislomid's estate.
So the only reason why Judge Fonts, the only judge who could handle all the claims is as long as the claim that I've told you in my hypothetical is going to fail and the counterclaim.
Yes.
Correct? If for some reason Judge Fonts can resolve those two, would you agree that the remaining claims could be transferred to the probate court?
No, because of the nature of the counterclaim and the other claims weighs on the facts. In other words, we would have to try the case twice.
Okay.
The fraud.
So let me kind of expound upon this question. So there's a quiet title claim, two versions of the slander claim, conversion, eviction, and insurance fraud. Am I missing anything?
I think that's about all we could think of, Judge.
Okay. So insurance fraud to me is sort of, I'm not sure how Ola Young and now her estate could win on not could win, but is vested with the right to bring an insurance fraud action. So let's
I can focus on that for you.
yeah, so
briefly.
so that's one question is how can Ola Young bring insurance fraud? That's question one. Question two is Judge Cameron's question all over again. We're left, so let's say I disagree. Insurance fraud is gone. Okay. Eviction, conversion, slander, quiet title. Those all can't be resolved in probate court because
Well, they can be, the slander of title can't be technically, but the title can be done. There's no question that Judge Shimke could deal with the issue of, are those deeds false and should it go back to my client, to Ola Young, deceased? The insurance fraud is they made a claim against the insurance policy on the property and they pocketed the money. That's the allegation. I can't get that in probate court.
right, but shouldn't the insurer bring that action and not you?
No, because the insurance policy was paid on the house and the money was to repair the house. Since the house is no longer repaired in the manner it was supposed to be, those monies, which we allege that Peters and Kashat put in their pocket, and in his papers, he kind of alleges they did a better job and did some of the work themselves. That's Ole Young's money that should have been put into the house, which was the asset.
So the insurance company says we can either pay the contractor who did work or we pay you, and that's our obligation. And once we've turned it over to them, if they pocket it or do whatever, you know, that's no business of ours.
It's not business. Well, theoretically, if the insurance company knew about it, they could have claimed that there was a fraud. I did not go there. I was in much after the fact. Now, so that's the basis of that case. I have to be honest with the court. I don't think that's the gravamen of the case. It's not the most important thing. I don't even know at this point, I have no discovery yet. I mean, we just got a scheduling order for Judge Shipke. So I don't even know how much is involved there. But let's assume it's $15,000 or $20,000. I'm not going to stand in front of this court and say that I'm arguing over a $15,000 or a $20,000 case. The asset is worth about $300,000, depending on the condition. I've never been into the house. I can't get an appraisal yet. I'm about to, I hope. So yes, to answer your question, she does have a damage arising from it. Now, one of the things that I think that the case law from all of your brothers and sisters who issued unpublished opinions seems to be, and it's case law that's also published. You have to look at the overall claim. If you look at the overall claim, the question was, I want you to quiet title in the name of Ole Young. That's what the pleading said, and that was the status before Judge Fawns. It wasn't put it back into the estate. Now, it makes no difference because once Kisloma died, it is effectively Ole Young's property. Okay, fine. So the question is, how many angels can dance on the head of a pin? I haven't said that since law school. It is a distinction without a difference. And I think what Judge Fawns saw, well, I'm not going to read her mind.
Let me just interrupt you for a minute, because I know it's, since you don't have opposing party, it's 15 minutes.
Yeah, I know.
Let me ask you this. Ole Young was your client, correct?
Yes.
Who's your client now?
The estate of Kisloma and the heirs at law, two of the three children of Ole Young. And I also will be representing the estate of Ole Young. The appointment of the personal representative is set before Judge Shimke on Monday.
So you represent?
Yeah. It's me.
Okay, got it. All right. Any other questions?
Oh, one other point I make. It is a very unusual case in one respect in terms of the facts, which is why it's so important to me. I don't know why it is, but it is. The warranty deed of this property out of the probate estate in 2006 was written on November 18, 2006. The warranty deed deeds the property from the estate to Ole Young and Ms. Kashat. Less than a month later, on December 1 of 2006, suddenly there's a quitclaim deed that quitclaims it from the two of them to the two of them with rights of survivorship. That is an unusual circumstance. I know you, aside from the fact that you're judges and deal with these matters regularly, as practitioners, that's not normal in the course of the world. With great respect, Your Honors, I think Judge Fawns is the only one, and not saying Judge Shimke doesn't know how to try a case. I'm sure she does. I'm sure I'll learn about that if you say no to me. But the only one who can give full relief is Judge Fawns, and it should be Judge Fawns. If the court has any other questions.
I don't have anyone.
Am I your last of the day?
I don't think so.
No, you were the first of the 11 o'clock call.
Yeah, that's
okay.
right. That's right.
All right. Thank you, Your Honor.
You're welcome. All right, that matter is submitted. Thank you. Turning now to item number 20, Michigan Ambulatory Surgical Center versus Esurance Insurance Company. It's item number 369465.
Good morning, Your Honor. It's Jeff Gould on behalf of the plaintiff appellants in this matter.
I will keep this brief. This is a appeal from a motion for summary disposition where defendant asserted that there was a limited PIP selection by the underlying patient in this matter, Ms. Howard, in the amount of $50,000. The trial court granted that, and I think there's three reasons, any of them on their own is sufficient for this court to reverse. The first is that they never showed that there was an effective selection by Ms. Howard to actually select a $50,000 policy. On the PIP choice form in the record, Ms. Howard's name is just typed out. There's no actual signature. Moreover, the PIP choice form that they produce is from 2020 when the accident occurred in 2022. They've never produced any type of form showing that she submitted a form to apply to the actual date of the accident. As it relates to the signature and just the type name itself, this court has already held in the Bronson healthcare case versus Esurance that a typed name alone is not sufficient to show that a applicant signed it under the UETA, which is the act that allows for digital signatures on forms and documents. Secondly, the Medicaid card, which is you have to be a Medicaid applicant to select the $50,000 limited PIP policy, was never produced at any time to Esurance when they sold this policy. So they had absolutely no knowledge if she actually was legally permitted to buy such a policy in their own.
Other than her representation that she was.
Other than her own representation, and I do think that creates a rather kind of issue on behalf of the policy for the state of Michigan, because it creates a situation where an insurer, to its own benefit, should turn a blind eye to any type of issue, because
That's always been an issue for me too. And the other side, of course, is, at what point do people have to take responsibility? I mean, you represented that you have whatever we're talking about at the time, in this case, Medicaid, but I mean, do they have to babysit and go back and verify what somebody represents to you is true?
I don't think it's as much as babysitting. Now, I will say the factual record on this one in terms of the issue of the Medicaid is very underdeveloped in the lower court. But just to kind of address your hypothetical, I don't think, for example, asking for a Medicaid card at the time of applying is babysitting. It's just making sure the ducks are in a row. And actually, following when this application was written, the Department of Insurance Financial Services issued bulletins indicating that when someone is selecting such a policy, that the insurer must receive such proof at the time of application. Now, those bulletins weren't in application at the time. This application was originally taken out. But
They're not binding anyway. Right?
And they're not binding, though. I mean, this court has said that they're due respectful consideration in terms of rules. But I believe it creates a situation where there's no benefit to the insurer to actually check and make sure that what they're doing is legally available. Why? Because if they are eligible to get it, then everything's fine. If they're not, then they just turn around and say, well, they lied and we'll resend. So it creates a win-win for them no matter what. But the simplest reason why this court can reverse the lower court is just they made the assertion that they had fully exhausted the policy of $50,000. And as we lay out in our brief line by line, simply there's nothing in the record before the lower court that $50,000 was actually paid out. I believe it was right around $47,000 and some change. Unless the court has any questions, I'll reserve any time for rebuttal, though I doubt there'll be much needed.
I have a question. So when you began your presentation, you said, I have three reasons why we should overturn. The first is the name's typed out and Bronson says that's not good. The second is the selection was 2020 and the accident happened in years later. What was the third?
Oh, apologies, Your Honor. The selection being 2020 is part of the PIP choice form. That is one that it only has a name typed out and it's from 2020, not 2022. The second reason, and albeit it's a very underdeveloped record for this argument, but that the Medicaid card was never produced at the time of application. So defendant, it's not even clear if legally she was able to purchase this policy at that time if she actually was a Medicaid recipient. And then the third argument is simply from the record, $50,000 has not been paid out on this. And so the policy is not exhausted.
Any other questions?
As for the Medicaid card not being provided, two questions with that. One, is there anything you can point to in the statute that would make it the insurer's responsibility to obtain a copy of the Medicaid card?
There's nothing direct in the statute. The only guidance would be the DIF's bulletins that have since required that it occurs,
And that,
But not in effect at the time.
but not in effect at the time.
and then is there anything in the record to show that maybe she wasn't on Medicaid? Do we know that?
We have no knowledge that she was at Medicaid at the time, other than just the PIP choice form. They did, after the accident, request her to give them a Medicaid card, in which she produced it at that time.
Okay. That's it for me. Sorry.
All right, thank you very much.
Good morning, Your Honors. Maureen DeMarco on behalf of Defendant Appellee Esurance. I will keep it brief like brother counsel and respond to his three reasons why plaintiff believes that this should be remanded. First and foremost, the argument as to the improper policy procurement relies on speculation and DIF bulletins. Those bulletins are not binding on this court. And two of the bulletins referenced were not in effect at the time of this policy procurement. Very simply, she signed a PIP coverage selection form approved by DIF. She certified that she had Medicaid coverage and she paid premiums for Medicaid coverage, meaning she only has $50,000 in PIP benefits available to her under the policy. There's no obligation imposed on Esurance by any provision of the No Fault Act that they need to obtain proof of Medicaid coverage. The bulletin issued subsequent to our accident even indicates that they should get proof of that coverage, and failure to do so imposes only the threat of potential administrative action and in no way indicates that your policy selection will therefore be ineffective, binding the insurance company to pay in excess of the coverage that was actually purchased by the insured. With regard to the e-signature, plaintiffs rely heavily on the Bronson versus Esurance case. However, it's important to distinguish that case from this one for a couple of reasons. In that Bronson matter, the claimant was presumed deceased. There was no way to confirm with the claimant that that was in fact her signature. Esurance is an entirely online company. If you're going to sign any document for Esurance, you have to log into your personal Esurance account with your username and password, and you can sign documents. There is no physical office that they can go into and sign documents. So it is Esurance's position that that signature does comply with the Uniform Electronic Transactions Act. However, if this court is going to rule in line with Bronson versus Esurance, it's also important to point out that the court did indicate that the typed signature alone may be insufficient to establish compliance with the Uniform Electronic Transactions Act, but it remanded the issue to the trial court for further discovery. The court in no way declared that this signature renders the entire selection ineffective. However, even if it did, there is a rebuttable presumption in MCL 500.3107C3, which we posit would nevertheless apply to this case as well, which I outlined fully in my brief. And finally, the payment ledger that was attached to the motion for summary disposition, I do, acquiesce in my brief that was unfortunately outdated at the time that the motion was argued at the court. But although this may have been an error, it was not a reversible error. The policy was nevertheless exhausted. Remanding back to the trial court for more discovery on that issue would lead to the exact same result. And I can open it up to any questions.
Thank
I
you.
don't have.
Thank you.
All right. Any rebuttal?
Very shortly, Your Honor. Just 2 points. The first point being in terms of the effective selection, sister counsel is speaking to the rebuttable presumption. The issue being is if we get there, there's nothing in the record to actually support that a premium was paid in accordance with a $50,000 policy, which is required under the statute for that presumption to apply. So we would, if we get to that point, we need to remand back to see if that actually occurred. Secondly, as to the issue regarding the outdated payment ledger, I would note that, sister counsel filed a motion to expand the record that was denied by the court. So that's not part of the record that should be considered. But even if it was, that opens a new issue for us. And that is to actually look into what those payments were for, because only some payments that an insurance company makes goes to the $50,000 policy, specifically payments under 500.31071A, specifically allowable expenses. If payments are made for things like settlements of claims, those may not be drafted in such a way to apply to PIP benefits. It might be a business release of claims, which are included in some releases. So even if you were to take the updated payment ledger, it should still be remanded because we never got discovery on this new updated payment ledger and what those payments specifically were for.
All right, thank you very much.
Your Honor.
That matter is submitted. Turning now to item number 21, Pitkowski versus Andiamo West, Inc., 373889. Oh, good. Thank you for joining us.
Good morning, Your Honors. Kelly Cruzy on behalf of the plaintiff appellants.
Connor Dustin House on behalf of the appellee.
See him?
Oh, let me, I think perhaps my, video. There we go. There we go.
All right, we can see and hear you.
Thank you. As Your Honors know, this is basically a one-issue case, and that issue is whether or not the defendant Andiamo had actual or constructive notice of the dangerous condition which caused my client to fall and suffer serious injuries. And we think that there were sufficient questions of fact that required the trial court to deny the motion because of both the character of the condition and the fact that it had existed for a sufficient amount of time where it was reasonable for the defendant to have discovered it. It was of that kind of character. It was water in a area that was used by both patrons and employees at the edge of the bar where the employees would come in and out, where they carried drinks, where there was a garbage, there were garbage cans, where there was ice buckets, the type of area where there's likely to be spills, there's likely to be water on the floor, and that would have been likely for the defendant to have identified it before Mrs. Pitkowski fell if they had been doing regular inspections of the area as they have a duty to do. I think it's important that in their brief at page 10, even the defendant acknowledges that if a jury were presented with the facts that were presented to the trial court, I'm going to quote, the jury would likely infer that defendant had notice in this matter. And so I think when you look at all of the facts and you take them in the light most favorable to the non-moving party and take all reasonable inferences from them, there are questions of fact as to whether or not the water on the floor was sufficient to give them notice that it had to be addressed. There are a couple of sub-issues that I think are relevant, and one is whether or not the trial court should have considered the affidavit of Sherry Sundberg. The trial court did not say why it wasn't considering that affidavit. It simply indicated that it wasn't going to consider it. And right off the bat, I would suggest that that is grounds for remand because it's difficult for you to assess whether or not the trial court abused its discretion in not considering that when there's no explanation given. The defendant has suggested that the affidavit was untimely and therefore shouldn't have been considered. And they refer the court to MCR 2.116 G1A5, which says no additional or supplemental briefs may be filed without leave of court. Well, the affidavit was not a brief. It was an additional piece of evidence for the court to consider on the exact issue that the motion was addressing, the issue of notice. So that court rule doesn't preclude the plaintiff from having filed that affidavit after the filing of its timely filed brief. And the Supreme Court in El Khalil versus Oakwood did say that a trial court must consider all the evidence submitted by the parties, again, in the light most favorable to the non-moving parties. So we suggest to you that the trial court, number one, erred by not explaining why it wasn't going to consider that affidavit. And number two, should have considered it, and it provides additional information concerning the question of notice. And then the other sub-issue is the testimony of the plaintiff that her husband told her that he heard an employee say that an ambulance should be called because Mrs. Bitkowski had slipped in the big puddle of water, not some, which again, if you draw a reasonable inference, is that that was something that they knew about. It was, oops, there's that puddle of water and somebody just fell in it. So defendant would like the court to conclude that that's a hearsay statement and it shouldn't have been considered by the court, but I would suggest that that's not the case. Evidence at the summary disposition stage doesn't have to be in admissible form. There has to be a plausible basis for admissibility. And even in the case of Gray versus Red Lobster, number 357165, 2002, the court held that at the summary disposition stage, the trial court can consider an unsworn statement of a witness. So that's really the situation we have here. And then what Mr. Vukovic, Mrs. Bitkowski's husband, heard the employee say would be non-hearsay under MRE 801. So we think both of those items, or both of those facts should have been considered. As far as the remaining issues that were raised in the defendant's brief, just a couple of them I'd just like to address briefly. One is the argument that there's no evidence that water even existed on the floor. And defendant cited a couple lines from plaintiff's testimony, but they didn't refer to that part of plaintiff's testimony where she specifically said that I do know after the fact that there was a water puddle. And in response to the question, you saw the water puddle? I believe when I looked over when the ambulance came, when I saw it. So she definitely testified that it was there. Her testimony is evidence. There's questions of fact on that issue. And one last thing, it's not really related to the notice issue, but defendant multiple times in its brief indicated that Mrs. Bitkowski was intoxicated. There's absolutely no evidence of that at all. The only evidence of alcohol consumption is that she had come straight from a job interview, had not had anything to drink before she was there,
Right,
and
that's
that,
a fact, right? That's a disputed fact.
yes, at most, yes.
Right,
It's-
okay.
Yeah, so your honors, for the reasons that I've set out, for the reasons in our brief, we're asking you to reverse the trial court and remand this to the trial court for further proceedings.
All right, thank you very much. Mr. Hess, good to see you again.
Thank you, Your Honor.
Go right ahead.
I'll first address the affidavit, but overall, I think regardless of the affidavit, this is clearly a case where no notice was, and plaintiff has not met their burden of proof regarding actual constructive notice. During the course of discovery, the only deposition that was taken was the plaintiff's deposition. Plaintiff had every opportunity to take the defendant's employees' depositions, the bartender who was there, the servers, anybody that was there. They chose not to. Okay, so I think the biggest point here is that plaintiff has not met their burden of proof, and they threw in this affidavit last minute. This is the plaintiff's sister. It took the plaintiff's sister over 2 years to come forward with this information, or 1 week before they realized that their case was about to be dismissed. She files an affidavit after the court mandated time to respond. They didn't file for leave. I'm not sure that the court rule clearly states and includes affidavits as supplemental. Affidavits may be filed with leave. They have to request leave to file. So they did not do that. The court didn't consider it. That's not an abuse of discretion. The court didn't consider it because it wasn't filed timely. Also, the affidavit itself is from 2 months prior to this incident. It's from we didn't have an opportunity, obviously, to depose Ms. Sundberg. She was never included on a witness list until well after the deadline to file a witness list. We actually filed a motion to strike that witness list and the affidavit. It was rendered moot because the motion for summary disposition was granted. But under the court rules, everything they did was improper, and the court didn't consider it because of that. That's why the court didn't consider it. I don't think it takes somebody looking, the court needed to directly address it. It's pretty clear why the court didn't consider the affidavit. And it was clearly just a desperate attempt to try and create a question of fact out of thin air. As to the actual facts of the case, and this case follows the Lowry roadmap. Again, plaintiff did not see, testified she did not see anything prior to falling. There's no evidence to show how long this.
Yeah, but if you create the condition, then you don't have to show notice. She doesn't have to show.
We don't know who created the
Well,
condition.
that's, and maybe that wasn't developed below, but all this business about notice, I mean, isn't it the law that if the defendant creates the condition that caused the injury,
Mhm.
notice is not a factor?
I would agree with that.
Presumed.
And
Okay.
I think the case law is clear on that as well.
Right.
And the problem is we don't know what created the condition. Plaintiff didn't meet their burden of proof. This isn't an issue where one person's saying one thing about how it was created in another place. This isn't a factual dispute. Plaintiff didn't depose anybody. They didn't meet their burden of proof. They haven't met their burden of proof. Her client cannot say where this water puddle came from. She claims that she saw it after she fell. She went to the bathroom once before and came back with no issues. Didn't mention any water on the floor at that time. So we don't know if a customer spilled something at that point from where she walked. We don't know what happened. The whole ice machine thing, that was from 2 months before. I don't know whether they fixed it or not, but we don't know. Plaintiff didn't meet their burden. That's what this is all about. And, I can't prove their case for them. And I can't do their work for them. But that's really what this comes down to is there's no proof that my client had actual constructive notice of this condition on the floor. And I think it's as simple as that. And the case law is clear. This follows the Lowry roadmap. If I cite a few other cases that I think this aligns with in my brief. And I do believe that this is right in line with those cases and should be followed. And the trial court's summary disposition granting should be affirmed.
Okay. Thank you. All right. Go ahead. Any rebuttal?
Yes, thank you, Your Honors. With respect to the fact that the affidavit is the sister of the plaintiff, I think defense counsel is making assumptions about relationships between people, relationships between family members, assuming that one family member would automatically know what happened. You can't make that assumption. That's something the jury would have to decide in terms of credibility. With respect to the affidavit, plaintiff's counsel not asking for leave to file the affidavit, plaintiff's counsel did raise that at the hearing on the motion, asking for the court to consider it. And there isn't anything in the court rules that says when the request for leave has to be made or that it has to be in writing. I would agree with Your Honor that if they've created the condition, and as I said, it's in an area that bartenders are working. It's in an area where wait staff is carrying drinks. It's in an area where employees are walking in and out. It's in an area where people are tossing stuff into the garbage. It's in an area where there's ice buckets. When you take reasonable inferences from the location, the amount of traffic that would be going back and forth there by the employees and by the patrons, I think reasonable inferences can be drawn that it would have been created, number one, by the defendant, but number two, if not created, should have been recognized by the defendant had they been inspecting as is their duty. With respect to the plaintiff having taken or gone to the bathroom on another occasion, she testified that she went a different way around the bar. She didn't walk past that same area. So that's really a red herring to say it couldn't have been there before because she didn't notice it on her first trip to the bathroom. She didn't walk that way. When she went to the bathroom at the time that she fell, that was her first trip in that area. So, Your Honor, we would, for the reasons I stated before and for the reasons in our brief, we're asking you to reverse the trial court and remand for further proceedings.
Am I correct, Ms. Cruzy, that you didn't handle this case below?
I did not.
I know your reputation and how thorough you handle cases, and that certainly wouldn't have been your method of conducting discovery in this case.
No, I was retained after the motion was granted for the appeal.
No other questions for me.
Okay, thank you both very much. The matter is submitted.
Thank you, Your Honors.
Turning now to item number 22, In Re Price Minor 374781. I have one party endorsed. All right, Mr. Sanford, what?
Especially assigned on the cases.
All right, hold on. Was this the? Let me see here.
Murray. Oh, no, yeah.
Shoot, let me make sure I've got the right case. What? Once you approach, sorry, once you approach and put your name on the record.
For the record, Sanford Shulman, P 43230. This is on the case of People versus Joshua Webb Smith, docket number 370661. It was scheduled 10, item number 15. Mr. Kuntz was is the assistant prosecuting attorney. I think he may have been here. I thought I spoke to him for a minute. It was called at 10:04, and I actually called the court. Judge Wanda Evans' courtroom called and said he might be a little late. And one time I was late. She had been called. So I understand it's scheduled at 10, and I was late.
No, that's all right. Was the prosecutor in this case here?
Yeah.
I think he was. Yeah.
He was here. And he rested on his
Yeah.
briefs.
That's what he kind of said to me. He said, going up there and see what they can do. All right.
Let me do this.
I mean, I'm happy to do it another day on Zoom and have him present. I know that I would not want my opposing counsel to talk. If I
Yeah,
wasn't
no, absolutely.
Yeah, and I don't want to put him in the defense. It was not his fault.
Let me see what we can do. Can we have is the clerk's office connected right now on Zoom? Can they hear what I'm saying? Okay, here's what I'd like to see. And we'll find this out. We're basically at the end of the, gotcha. We're basically at the end of the call right now. Let me see. I mean, he's in the Monroe County Prosecutor's office. If he went directly back, I see the clerk's office is now connected. Thank you very much.
Okay.
I'm interested to see if we could reach out to the Monroe County Prosecutor's office, have either this prosecutor or any prosecutor, really, well, this prosecutor really, connect via Zoom, so we can use Mr. Sanford's Schulman's time since he's here. Is there any chance that we can do that?
I can go ahead and give them a call and see what's available. We would be able to forward some sort of link if anybody's available at this time.
Yeah, thank you. And just for your benefit, the person endorsed from the prosecutor's office is Adam Kuntz. Was that the same individual who put his appearance on the record? All right, let's see if we can if you could reach out to the prosecutor's office, to Mr. Kuntz, find out if he's available, send him a link if possible, and then we'll have him on and we'll have argument, give the defense an opportunity to do that. If he's not there, if you could also ask if there's just a member of the prosecutor's office who would be willing to just be on the record. If
Okay.
you're comfortable with that.
I'll do that. I'll call immediately and report back. For the schedule, it looks like there's just a few remaining following this. So
That's right. So what I'm hoping to do, so let's do that. Let's do that. And we're going to probably, Mr. Schulman, what we'll do is we'll be in conference. And then if we are able to get him on Zoom, they'll pull us out of conference and we'll hear the case.
I appreciate the accommodation.
You bet.
I'll
you
stay
bet.
right here. Thank you
No
again.
problem.
Okay,
Okay,
thanks.
thank you very much.
Okay,
Why
great.
don't we'll just wrap up the last two cases because I think we
Oh.
still have a couple more. Sorry.
3, yep,
Yeah, we've got a few more.
4 actually.
Without
Yeah.
argument.
Correct, I'm just gonna put them on the record.
At a price, I think is the first.
Yeah, I was just putting the case, I'll put it on the record again, in Ray M.A. Price Minor 374781. At this point, no one is endorsed any longer. The matter is submitted. Item number in Ray Broom Minor 374685 consolidated with 374687. Ms. Miller was endorsed. I believe she's waived. That matter is submitted. Item number 24, in Ray Israel Minor, item number 374702. No one is endorsed. Item is submitted. Consolidated number 25, which is in Ray Street Estate, 370581 and 370582. Consolidated. No one is endorsed. The matter is submitted. That concludes call. And then we're going to begin our conference, and if we're able to pull someone or find someone in the Monroe County Prosecutor's Office, good deal. All right, thank you all very much. That concludes the docket. Court of Appeals of the State of Michigan is now in session. All right, recalling the case of People of the State of Michigan versus Joshua Smith, 370661.
Good morning, Your Honors. My name is Sanford Schulman. I represent the defendant appellant, Joshua Webb Smith. I want to first thank is that Adam Kuntz? I think he's on Zoom. Is that him?
Isaac Skaggs, filling in for Mr. Coe.
Oh, okay, very good. Well, I appreciate you doing that. I was a bit tardy this morning, and I know good deed goes unthanked, I guess. And I appreciate you being there, and I appreciate the court allowing me to add this to the end of the docket.
Not a problem.
And so I'll be relatively brief. I know the initial brief.
Just don't say after all this that I'll rely on my.
Now I have to talk. Now I have to talk for a couple hours, I guess. No, I know that the court has read the brief, and the brief and the supplemental brief. I want to take this opportunity or argument to really focus on sort of 3 areas. First is the jury selection. As a practicing attorney, I enjoy doing appellate work. Sometimes I cringe, and sometimes I'm enamored by the skills, sometimes the things that I would do and wouldn't do in a trial. And I thought about this issue of the veneer and how to select juries. In this case, I think there was juror after juror after juror indicated that they had some history or family history of sexual assault. And some of it was pretty graphic. And I think about what would a prosecutor do if the veneer had indicated that they had members of their family who were falsely accused of crimes or assaulted by police officers or acquitted of murders that they hadn't committed. The prosecutor might stand up and say, listen, this is a poisoned veneer. I got to ask for a new one. And I think that this is sort of what happened here. 3 of the jurors, I think, stayed on the jury with those kind of historical comments. And I understand that we have to presume that a jury and the government cited the appropriate law, but still, this was a little unusual to see juror after juror after juror. And there wasn't even use of preemptories to even balance out a bit. So my first issue presented those kind of factual concerns in terms of the veneer, the selection of the jury.
I want to clarify that issue, understanding that the original brief, anyways, they both exist here in the court. So is your argument that the entire veneer was polluted?
Yes, I think because of such a prejudicial, I guess, the effects of potential juror after potential juror, and even the ones that stayed on the jury, it just, at some point, a judge would say, we need a new veneer. And I don't think it was actually requested, but I think that it was something that the judge could have done sua sponte. The defense attorney didn't make a record of that. He didn't ask for it. But a review of the record, I think, would suggest that it was so ineffective not to have just asked for a completely new panel. But yes, I guess the short answer is I would have requested an entirely new veneer, given the severity of the type of charges and the types of emotional baggage that comes along with this and the comments of the jury. And I'll rely on the balance of my arguments on that issue. The second issue really focuses on the child forensic interview protocol. This was a detective, I think he had done his first one. He did it in the police station, which was a little unusual. There's a protocol that's pretty strictly followed. The one area that I thought was problematic is he didn't really assemble a team. Often protocols, they have different social workers and other people involved. They also test by giving alternatives to the facts. Here you have the defendant's daughter who sort of suggests she got much of this from a dream, or there was some dream. It was a little bit things I call red flag in terms of the historical background that she provided to the officer. So we challenged that, and part of me said, I got in the case obviously late. I would have had an expert. I think part of this case was that the defense lawyer failed to file an expert witness list timely. He was called out on that at pretrial, and then he said he's not going to call one. And that would have been something, and I've been in touch with various these child forensic interview specialists, and they really critique how the interviews are done and how suggestive they could be done. In this case, what was even more curious is that there was a second daughter who testified exactly as the first, and the jury acquitted the defendant of all the charges there. It was just completely mirrored it, and it was sort of the same kind of idea. The protocol that's applied to the specific case. There was also an issue of some medication that the complainant was receiving and how that affected her, and whether there was sufficient testimony regarding that in terms of fleshing out those issues. So we raised that on appeal as well.
And she, in her testimony, denied having any side effects to the medication.
Right. There was some issue of hallucinations, dreams, how it affected you. And the defense did object and asked for more instructions as to that, the medication that was being used and how it affected her and how the jury is going to interpret that. And so that was kind of an issue that came up and that we raised on appeal as well. I think the defense, and I'm trying to look at where exactly the citation was, but at some point they raised that as well. The last area is the jury instruction, and that was because this is a case where the defendant is our resident nurse. There was some testimony that he was providing some massage therapy to the daughter. In this kind of case, the definition of sexual conduct was important. I think they used the model jury instruction as part of the instructions, and the defense objected and asked for further instruction, and that was denied. So in short, the defense would incorporate the arguments in the initial brief as well as the arguments in our supplemental brief. And I'm trying to find the name of that medication that she was taking, but
Singular.
yeah, that's it. Singular. Right. And so those are all the issues that were raised. And I think if I look back and was to try this case, I would have been very concerned about the jury selection. I would have been challenging the protocol of the child forensic interview. And in the end, I would have been much more adamant about this singular medication and trying to get more clarification of what that does and how it affects the complainant. But on that, I would rely on my brief. And again, I thank you for your patience and staying a little later, and for the people for coming back on this Zoom.
Okay, thank you very much.
Thanks, Judge.
Is there anything from the appellee, or are you satisfied?
Your Honor, I believe Mr. Kuntz rested on his brief. At this point, it would be our intent to do the same.
Okay, thank you very much. And Mr. Schulman, it's good to see you again. And a special thanks to the Monroe County Prosecutor Office for pitching in on this. Thank you.
Yep. Okay. Have a good day, everyone.
Yep. All right, matter is submitted.